We are back on Morning Line. Thanks for joining us. Barbara McGinnis is with us. Take us to McGinnis, and we were just talking during the break again. More than 3 decades, 3 decades as a nurse practitioner?
23 years.
23 years as a nurse, and then she gets her law degree. Yeah. You've got the perfect background for what you're doing now.
It really does come in handy.
Yeah, I mean, that's... listen, let's take a phone call from Ronnie. He waited through the break, and then we'll get more into some of the details you want to talk about. Ronnie, good morning. Hi, Ronnie.
Hello, good morning, y'all.
Hey, how can we help you?
I got a question. I don't know if this can help me or not. If somebody has got, I heard her say something about, where you sign your rights away. And can the person, if they don't want their rights signed back, how do you get your rights back once you sign them away? And what process do you have to go through to prove that you can handle it?
Oh, okay. Well, now I'm wondering, are you saying that this was a power of attorney you gave someone, or did someone
it's like
get control of your entire estate? Conservatorship.
Like conservatorship. That's what it sounds like.
She gets her money through, say, her sister or her mom.
Yeah.
And her sister or mom took over her money situation, went to court and got it where she's control over everything.
Gotcha. Okay, I think I know where he's going to. All right, go ahead and maybe explain. I think you're right. It sounds like conservatorship. Yeah. And Tim's told me this before, and I think you have. That's the last straw. That's the last thing I want to do to any of my loved ones.
I think a lot of people don't know what options exist other than filing a conservatorship.
Well, explain what that is.
And sometimes it is necessary, but I don't think it's necessary in every case that it exists, right? A conservatorship is where someone goes to court to have someone's, they don't really perhaps know they're having someone's rights taken away and vested into themselves. They just know that they don't have legal authority over someone and they need the court's permission to do certain things. Maybe it's take care of their banking or make healthcare decisions for them. So the court can award a conservator over the person, which is about healthcare for that person, or the property of that person, which is banking and financial management for them. Now, Social Security has a system that works all by itself. It's called a rep payee system, and so if that's the only income asset, you're rep payee through Social Security, and then that person is responsible to report to Social Security once a year what they're doing with the funds. Okay, so if you have a power of attorney and you want to revoke your power of attorney, as long as you have capacity, you can revoke your power of attorney in writing. You have to notice your agent that you fired them. You may have to record the document of the revocation. You can appoint someone new. So
that's different, by the way, than a conservatorship.
That's right. Power of attorney is really keeping the authority within yourself. You're just delegating someone else to act for you.
I have that for my folks, okay?
Sure.
And so, but it's not taking away their control.
No.
Yeah.
A conservatorship. So how do you go about the process of
let's say this, though. The conservatorship oftentimes is not taken with the permission of the person you're seeking it from.
Oh, absolutely.
Maybe they don't really know, and you're forcefully going to a court and saying, look, based on these medical records, my mother is no longer competent to care for herself. Right. You may have a doctor testifying on your behalf, and the judge, and the mom may say, wait a second, this is my stuff, you can't do that. And the judge can overrule her and take it.
Right.
If his question is then, how does that mother fight back?
Well, it's still a legal process.
Yeah.
The person should have, through that court conservatorship process, should have a guardian ad litem appointed. A guardian ad litem is an attorney that does not really represent the conservatee or the conservator, but is more like the eyes and ears for the court. So there's neutral. The conservatee, the ward, could ask for a guardian, an attorney ad litem. So an attorney to be appointed through that process to represent them, and then that's how they challenge the court process.
All right.
And say, no, and you find your own doctors that say you are competent.
The truth is, unless it's and sometimes maybe I don't know if you've come across this, where there's just an unscrupulous son trying to just get to mom's money and figures, okay, I'm just going to get her, under my control. If I had to seek this out, it would only be because I realized that my father and mother had such advanced, perhaps, Alzheimer's that they truly could not manage it anyway. And it would be the very last resort for me. I mean,
then if you had a valid power of attorney, there's no reason that you couldn't function under the authority of the power of attorney.
That's right. So that's what you would need, right?
Right. And so the magic words durable power of attorney is durable through a period of incapacity.
Okay.
Not death, but apparently long ago, before I started practicing law, it was common to draft powers of attorney that were not durable. And you meaning that they were time limited, or they were conditional upon a certain factor.
I see.
So if you don't have those durable words in there, then when the principal loses capacity, the agent loses authority. So durable is real important.
Okay. All right. So the idea is, the odds are they're not going to get any better, right?
No,
So they're going to continue to need to depend on it. Power of attorney, though, also, and I'm trying to think, I mean, we've done so many legal things with my folks, is that I know I have it, and I know I have it for their financial issues. I think we also have it as it relates to medical to some degree. But here's the difference. The doctors will not tell us, because of the HIPAA laws, some of the things that they discuss with the folks. Now, sometimes my brother will sit in with them, and my folks don't care, but they'll forget what they were told, and then we'll ask the doctor, well, what exactly are you doing? Well, you go, well, I can't tell you. That's HIPAA. It's your parents' business. And so, do we need to upgrade it so that we say, wait, doc, I've got medical here. You can tell us what you're diagnosing.
Yes. I mean, our documents would include HIPAA language in.
But standard, and ours may. I mean, we haven't had to deal with too much of that. But if not, I just need to address that to make sure that we can, because then we need to know about meds and doctor's appointments.
A lot of times it's as simple as, here's Dad, give the doctor permission to talk to me.
Right,
kind of
that's
thing.
right. Yeah, that's a great point. And because the parents are along the ride for that, and they'll say, sure. Even though they may not be completely understanding what's going on, but they'll agree to it, right? And the judge will go along with that. All right, so as far as getting out of a conservatorship, it's not an easy thing to do.
It is not an easy thing to do.
Okay, so that's the answer then for Ronnie. But the number again, 737-7587 if you want to jump in. But you said something very important coming up with VA rule changes?
Big rule changes coming up.
A lot of veterans out there. So.
A lot of veterans, yes. Significant rule changes for the non-service connected pension benefits. So I think that's something truly
non-service connected pension. All right, I want to get into detail on that. She said we have to take a break. Let's take a break.
Okay.
We'll get into that when we come back and what it means and what these changes could do to certain benefits. Stay with us. We'll be right back.